Hi, today we're going to be talking about what do you do when the VA is trying to take away your benefits. So we hope that you'll join us for that discussion. Hi, and welcome back to Hill and Ponton's VA Disability Blog. I'm Natalia Joffrey, the company COO.
And I'm attorney Ann Lynn Scott.
Hi, Ann. How are you?
I'm good. How are you?
Good. We continue our little remote recordings as a result of the ongoing pandemic. But I think that today's topic is especially important because a lot of people are concerned right now about losing income and getting reviewed and what would they do with the job market the way it is and all of that good stuff. But I want to go back a little bit first regarding what might happen to someone. So I guess my first question would be, can you give us an overview of why the VA might want to try to reduce a veteran's benefits?
The underlying purpose of the VA disability benefits and the amount is to reflect the severity of symptoms that the veteran's going through. Some conditions, for example, cancer, if it's active, then you have cancer and it's obviously very debilitating. And then if you're in remission or you no longer have cancer, while there's still going to be problems, you're in some sense, improved. Those situations where the VA does look to see, is there any kind of likelihood that it might get better? That's kind of wherein lies how proposed reductions can come around. A lot of times it comes from the VA doing re-examination. So review, compensation and pension exams, C&P exams. That will be kind of a triggering event as far as VA looking at a condition and whether or not it needs to be reduced.
So in a nutshell, would you say basically if you've been awarded benefits or a rating based on a condition that can be expected to improve? So for example, like you mentioned cancer, if you're actively battling cancer, but then it goes into remission, that might prompt a review. Would you say that's
Right.
an
And a
accurate?
lot of times, another just straightforward example, if you have service-connected condition and you're having surgery on that, temporary 100% rating, so you'll see it a lot with knee replacements. The VA will automatically assign a 100% rating if they know about the surgery. And then they almost just automatically say it's going to be reduced. We see a lot of times 30% on a certain date. If that happens and you're still dealing with things, the VA sometimes, yes, automatically, like you said, with the cancer or, in the example that I said with the surgery, they'll automatically set a reduction rating in there on a certain date. And then it's up to a veteran to explain why that 100% rating should go further. So paying attention to rating decisions, because sometimes in there it will say a temporary 100% rating is granted, but kind of buried in there, it might give a date that a reduction is coming. They can reduce any kind of rating. It doesn't have to be the temporary 100% or cancer. If it's going to result in a reduction to your actual monthly benefit, they have to send you a notice.
How much time do they give you? Like how much notice do they give you?
So if you get a notice, you have 60 days from the date that's printed on the notice. The date that you receive it. To be safe, I would go with the date that's actually printed on the notice, usually the top left-hand corner around there. You have 60 days to submit evidence or, an explanation as to why the reduction shouldn't take place. You have 30 days if you'd like to request an actual personal hearing on that. A lot of times what we see is pretty effective is if you've got the evidence, just submitting that, maybe a statement explaining, why the reduction shouldn't occur, or a legal argument, something like that. A lot of times the personal hearing, it kind of depends case to case, but about 60 days before they're going to do anything.
Okay, so that's good to know for planning purposes. So if you're getting a notice in July and it's got a date of July 1st, you know that you're covered
Right.
income wise for a couple of months, that you're probably not going to actually see the loss or reduction in benefits for at least 2 months.
When you get a notice, they're not actually reducing it right then. You can't actually appeal until they take the action. But because of the laws and protections in place, the VA has a duty to notify the veteran and the representative anytime there's going to be an adverse action taken. They're not going to actually reduce your benefits right then because the veteran has had an opportunity to respond. You're going to be getting paid until the reduction actually takes effect. Just like with any rating decision, once they actually take the action, then you have full appeal rights. So you can appeal it, higher level review. If you get that decision that actually reduced you and you weren't able to get new evidence in the 60 days, but now you have it, then you
Uh-huh.
appeal into the supplemental with that new evidence you have. So once they actually take the action, of course, you want to try to prevent any reduction from happening. But even if it happens, that's not the end of the road.
So if you're getting a notice in October that says we're going to take this action, we're going to reduce your benefits, is the reduction then taken immediately or is it taken approximately 60 days within the notification date?
If we're using your example of July was the proposed
Yes.
notice, if in October you're getting that decision, it will say we have reduced your benefits.
Okay, so then at that point it is
It's,
immediate.
yeah, the date of that letter. The decision could be, we're not reducing your benefits.
Right.
A
Right.
notice and then a decision as to what the actual steps being taken are.
And just one more example that I think might be helpful. So we talked about cancer, we talked about knee replacements. Of course, these aren't the only conditions that you can be reviewed for a reduced rating. Are cardiac conditions evaluated in a similar manner in the VA?
I would say, yeah, that's another good example of a condition that you might have a heart attack or you're having surgery, a bypass or something like that. And that result in those temporary 100% ratings. Anytime that there's a temporary 100% rating, there's going to be some type of reevaluation, whether that's the VA looking at your treatment records to see what's going on, or a lot of times they'll order an exam for the veteran to go to. But definitely heart conditions are another one where you see, any kind of condition that might result in needing some kind of surgical procedure or hospitalization. That's definitely going to be kind of a common thing where keep an eye on what the VA is doing with your rating to make sure that they're not reducing it incorrectly.
Great segue into my next question. How can you avoid having your rating reduced or reviewed?
So there's not much you can do as far as preventing the VA from asking for an exam other than just depending on how long you've had a certain rating. If you've been rated for a condition less than 5 years, for example, the VA can schedule a re-examination to evaluate the condition. You can't really stop them from doing that.
Anytime, as often as they want?
If you get a rating decision in the decision or on the last pages called the rating code sheet, you might see where they have noted on there when they expect to schedule it. It's not usually more than once a year. They're not going to be scheduling exams, every other month or something to look at a condition. As we know, the VA has a lot of other things they should be doing. But I can't say that there's nothing you can do to stop them from ordering an examination. It's obviously important to go and be honest and upfront about everything. And then if they do try to reduce it, then there's steps you can do.
Are most veterans reviewed on an annual basis, or is that mostly just for the veterans that have conditions that expect improvement?
So conditions that they would expect improvement, or sometimes, especially with unemployability issues, an example would be a veteran who's, let's say, 35, we're trying to go for unemployability. They grant unemployability, but they don't say that it's permanent. Sometimes that will when a veteran is young or they haven't been out of service for a long time. In those kind of situations, or both, especially if it hasn't been long after service, the VA might hesitate to, if it's unemployability, find it permanent. The hope is that someone will get better and things will improve. A lot of times that doesn't happen, but those are kind of two factors that could kind of trigger the VA into looking at it or keep them from saying that they won't schedule an exam.
I'm glad that you mentioned in your example the veteran's age, and that makes me wonder, is a younger veteran more likely to be reviewed than an older veteran? Is that something that the VA takes into consideration? So like in your example, a 35-year-old, are they more likely to be reviewed versus a 55 or 65-year-old?
So potentially, and that brings in, I call it the 55-year-old rule. The VA can reduce a rating regardless of your age. They can still technically reduce ratings that have been in effect for a long time. There's just, as time goes on, there's more and more protection. 55-year-old rule, that has to do with the VA ordering re-examinations. So it ties into proposed reductions, because someone who's 55 or older, unless there's clear medical evidence in the record showing that this person's all of a sudden gotten better, they shouldn't be getting scheduled for a re-examination. So yes, to a certain extent, age kind of does play a factor. It's no blanket rule that says if you're 40, you're going to get one exam a year. If you're over 40, it's every other year. But that's kind of something the VA will take into consideration when they're looking at what's the likelihood that something's going to improve.
Yeah, that you're gonna get better. Not that you're going to, because there's conditions that are never going to improve, but the way they look at that is, a 35-year-old has much greater likelihood to have improvement than a 65-year-old. And I mean, I
Right.
think that's reasonable for anyone to think, once again, depending on the condition, right?
Exactly.
And you already talked about appeals. So, just to kind of clarify that issue again, bottom line, from the date that you get a notice, it says, we are going to reduce your benefits. That's effective immediately. Tell us a little bit how much time you have to file an appeal.
So when they actually issue a decision saying you've been reduced, it's like any other rating decision. You have a year to appeal.
Okay. Wow. A year.
When it comes to reductions, if they actually take action on the proposed reduction, the sooner you get an appeal in, the better, as far as, you want them to make a new decision on it. But if you get the proposed reduction, you have 60 days to submit evidence. Life happens if you can't get evidence in, or you do, and the VA just doesn't think that it is enough to outweigh what their evidence says. You may need to take some time to make sure you've got the evidence to overcome the reduction that was taken, but you do technically have a year from the date of that decision. If the reduction takes place and you appeal it and they say that it should have never happened and the increased rating should go all the way back to when it was, then obviously there is going to be a retroactive award with that, because
Okay.
you would have been getting some reduced pay.
Well, you preemptively answered my next question, so that's great. Because that would seem fair for you to then get that retroactively. So since we're talking about appeals, how often do you see the VA take a reduction incorrectly? How often do you feel it's fair to file an appeal?
Almost always. I mean, at the very least, there's certain things you need to pay attention for. So while reductions come from a lot of times the fact that they schedule a C&P exam to reevaluate everything, the reduction itself can't just be based on that exam's findings. It has to be based on the entire medical history. You can have good days and bad days in any disability. Just because you have a good day when you're at a C&P exam doesn't mean that they should reduce your benefits. So they're supposed to be looking at the whole picture. That doesn't happen a lot. I would say it's common for the VA to just look at that one exam and say, oh, well, it looks like, his sleep is doing better. He's having less nightmares. So we're going to propose to reduce them from 50% to 30%. That's not in line with the regulations unless there's medical evidence showing that they can't just look at the one picture of the C&P exam. For any rating, regardless of how long it's been in effect, they have to show improvement happened during the circumstances of what they say ordinary life. So that would be while you were still going to work every day and living a normal life, versus your condition improved because you're able to sit at home and rest. Would that improvement have happened if you were living ordinary life? And so if the improvement in the condition was only an improvement because the veteran was able to be at home and relaxing and resting and things like that, then that's not a material improvement. They shouldn't be reducing.
That's not real life. That's not realistic, right?
Exactly.
So the next thing I want to talk about, these protected disability ratings. Can you tell us a little bit about what a protected VA disability rating is?
Like I was saying before, the VA can try to reduce any rating, but as you have ratings for a certain amount of time, as time goes on, there's levels of protections going on. So that starts at 5 years. At 5 years, if you've had a condition that's been rated the same rating for 5 years, it's referred to as a stabilized rating. They could try to reduce still, but it's less likely. They have to actually show sustained improvement. Burden is always on the VA to show this. Yes, the veteran should submit things that show otherwise or explain why the VA shouldn't be taking this action. But the fact that the VA has this burden of proof is something that a lot of times you can point out and say they didn't meet the burden of proof. So 5 years is the first one. 10 years comes in when we're talking about severance of benefits. So if a rating is in place for 10 years, that rating itself, same kind of rules as 5 years. It's a stabilized rating. If you've had that condition for at least 10 years and it's been service connected for 10 years, the 10-year rule helps protect the VA from actually taking away service connection. So there's reducing the rating, from 50 to 30, from 20 to 10. They can also try to just take away service connection in total. For the 10-year rule comes into play, it helps protect severance of service connection.
What is the 20-year rule for VA disability ratings?
20 years, that is kind of the next, you have the 5 year that applies to ratings. So 10 years kind of a side note protection, if you will. It's not necessarily protecting a rating from being reduced. If you've had a rating for at least 20 years, it's called a continuous rating, and that means the VA has to show actual change in something. So it's a higher level of, again, proof that the VA has to show. And so that does give a veteran more protection. Basically, the VA has to show that a rating was based on fraud, which is a
Oh,
pretty
wow.
high standard. It's not just a difference of opinion, so to speak. The VA has to prove a lot more than that to try and take that
Okay.
away.
What happens if the condition worsens after 20 years? Can they qualify for an increased rating? And if so, is it then protected?
You can definitely file a claim for an increased rating. So if you filed a claim 20 years ago, you got a rating and you've had it for 20 years, but you never filed any appeals in there, if you feel that your symptoms are worse and you file an increased rating claim, you can get that increased rating. When it comes into, does it go back? It can go back retroactively. And so if you've been fighting with the VA for 20 years, there's been continuous pursuit, so active appeals that allows the effective date to go back under effective date regulations. If the evidence shows that the increased rating should go back also, then yes, then the increased would be protected. So if you file a claim for an increased rating and the evidence shows that the increase should go back to just that new claim, it's not going to automatically be protected. So you would still have the lower rating. So let's say you had a 20% rating for 20 years, that's protected. And then
Okay.
you get an increased rating of 40%. Then that 40% rating, the clock starts over again. The date of your claim can't go back. You haven't been appealing decisions continuously, or there's not a way to get the effective date back to that beginning of the 20 years, then the increased rating claim would not be automatically protected.
Are combined ratings also protected under the 20-year rule?
Yes. So you're looking at your individual ratings. All of these protections apply, as does the combined rating. Now, the combined rating is usually the VA wants to reduce a single condition. If reducing that rating wouldn't affect a veteran's combined rating, then one, they don't have to notify the veteran. And two, there's not much you can do. I mean, you can try and appeal that decision, but because there wouldn't be any adverse action as far as your monthly benefits are staying the same, all of these protections don't necessarily apply, because what it's coming down to is the VA has to notify a veteran if there's adverse action taking away their benefits. So if this adverse action isn't going to change the amount of monthly benefits you get, which is based on your combined rating, it's an issue if it's incorrect, but it's not necessarily affecting your payment.
What if the diagnostic code changed? What is and isn't protected then?
The protection comes into play where if a new diagnostic code or new rating criteria comes out and it would in effect reduce the rating, then those same kind of protections have to apply as far as what symptoms are being compensated for and how long have the ratings that reflect the severity of your symptoms, how long have those been in place. So the diagnostic code, if it changes and that would result in a rating reduction, then you want to look and see. The raters are supposed to be very careful about if they think a diagnostic code should change, because they do need to make sure that at the end of the day, it's really the symptoms that should be getting rated. You know, sometimes there's not rating criteria, there's not a specific diagnostic code for something. And so you always just want to make sure that whatever diagnostic code the VA is using for you is adequately representing the symptoms that you're having, and making sure that if they try to change that on you, if your diagnostic code changes and it doesn't change your rating, then there's not necessarily a problem. If there's a change in the rating criteria or change in diagnostic code, if that's going to result in a rating being reduced, think all of these rules that we've gone through.
Speaking of rules, you covered the 5-year rule, you covered the 10-year rule, you covered the 55-year-old rule. What is the 100% rule?
It's an added level of protection. So it can't just be similar to the 5-year rule. If you have a 100% rating, but you've only had it for 2 years, they still have to show what's called material improvement. So it works similar to the 5-year rule in that there's added protection to it. But if your rating is 100% versus if it's 10%, it doesn't have to be there for 5 years.
So what is TDIU, and is that also protected?
It's total disability based on individual unemployability. So total disability is 100%, but the 100% is based on the fact that the veteran can't work. So your combined rating might be 70%, but you're treated as though you're 100. That is subject to protections as well. And so with TDIU, whereas with all of the other things we were talking about, material improvement, did your condition, did the symptoms get better? With TDIU and whether the VA can take that away, it's more, is there improvement such that the veteran can now find and maintain substantially gainful employment? Symptoms come into play because obviously it's the symptoms of the underlying condition that affect a veteran's ability to work. Talking about whether the VA can take away TDIU, they're really looking at, can they all of a sudden now find substantially gainful employment? The question shouldn't be, can the veteran find a job? It's, can they also maintain and keep that job?
And TDIU, to clarify, same thing that's referred to as permanent and total?
It can be permanent total, but TDIU in and of itself is not automatically permanent. Permanent means the VA acknowledges that there's not likelihood of improvement. When veterans get permanent and total, you can't really be permanent without being total. You don't hear just permanent, but that means that not going to be scheduling these routine exams. And so that kind of, without re-examinations, you're not entering into the world of possible proposed reductions. For the most part, you'd see cases where the VA is granting TDIU, it's going to also be permanent, but it doesn't have to be.
Well, this was super involved and lots of really good information, I think, for veterans to know what to expect if they're going to be reviewed or if they are being reviewed, or even if they're awarded benefits, what they can expect to happen in terms of having their ratings reviewed and
Right.
possibly reduced. Well, thank you, Ann. We appreciate it.
You're welcome.
And we thank you for joining us. We hope you'll do so again. But in the meantime, if you have any questions, please feel free to visit our website or call our office.